I want to begin by acknowledging that the land on which we gather here in Ottawa is the traditional unceded territory of the Algonquin Anishinaabeg people. Good morning, or good afternoon, as the case may be, to everyone. Bonjour tout le monde. My name is Roger Clark, and I will be chairing this press conference. I also represent Hassan Diab's support committee, along with the many thousands of people who have worked tirelessly over these many years on behalf of Hassan. So welcome and greetings to all who are participating from across Canada. I particularly want to recognize the presence of the Canadian Association of University Teachers, with Lisa Keller, the communications officer, and the Ottawa University Human Rights Research and Education Centre, with John Packer, the director. A quick word about procedure. There will be three speakers. Donald Bayne first, Hassan's Canadian lawyer over the past 12 years. Alex Neve, former Secretary General of Amnesty International Canada, and now Senior Fellow and Adjunct Professor at the Universities of Ottawa and Dalhousie. And then thirdly, Robert Currie of the Schulich School of Law, Dalhousie University. He is Professor of International and Transnational Law and author of numerous academic papers on Canada's Extradition Act. Following the three presentations, there will be questions from participating journalists. And I should mention that this press conference is being recorded and that the International Civil Liberties Monitoring Group is also providing a live Facebook stream. So I pass this over now to Don Bayne, who will comment on this morning's decision in Paris and what it means going forward. Don.
Thank you, Roger. I'll preface my remarks by making plain that I'm dealing only with the criminal law and extradition law issues, not at all with Dr. Diab's pending civil case. The decision of the French Court of Appeal today is the continuation of a long odyssey of injustice. It's not only that, it flies in the face of the existing evidence. You'll recall that this is a case in Canada that was based on a sheer opinion, a handwriting opinion, that the world's leading experts all unanimously agreed was completely unreliable. You'll remember as well that this is a 40-year-old investigation into an event in Paris in 1980 for which the French have never been able to attribute decisively responsibility. So French authorities have been under pressure from a powerful lobby, and they ultimately came up with two so-called expert handwriting opinions saying that a Canadian university professor was the author of the printed hotel registration card that the real bomber in October 1980 registered with in a hotel in Paris. It was then exposed during the course of the Canadian extradition proceedings in court that through international handwriting experts, that the so-called French experts didn't realize they were actually using to compare with the printing on the hotel card the wrong person's handwriting, not Hassan Diab's at all, but a woman. And they unwittingly identified a woman in California as being the bomber, who was described by hotel personnel as a male in his mid-40s. Hassan Diab, by the way, was 26 years old in 1980. Rather than collapsing the case and encouraged, I might add, by a Canadian Department of Justice lawyers, the French sought to recruit a replacement handwriting expert, and this third expert, one Ms. Bissotti, conveniently opined for the French that that indeed Hassan Diab was the author of the printing on the card, and this became the only evidence justifying extradition from Canada, so that Dr. Diab spent 3.5 years in solitary confinement while investigators in France continued to investigate the case. It turned out to have been an extradition for investigation contrary to law, rather than an extradition for trial at all. Despite the leading experts from Canada, the United States, United Kingdom, and Switzerland, all giving evidence that this handwriting opinion was completely unreliable because it used improper handwriting identification methodology, and the writing was not amenable to identification, being block printing. The evidence was held by a Canadian court to be reliable enough to deny a Canadian of liberty. It was sent to France. Back in France, with this expertise being criticized by international experts, French authorities asked a fourth and a fifth handwriting expert in France to come up with yet another report comparing Dr. Diab's handwriting with the printing on the card. These fourth and fifth experts have recently completely agreed with the defense experts that testified in Canada that the report of Ms. Basati on which Dr. Diab was extradited is completely unreliable. Dealing with the scientific methodology, in their report, they talk about the scientifically inadequate methodology for assessing similarities and differences. And then they set out the critique, which was lengthy, of the international experts. Their opinion: we are in total agreement with the defense experts. They also agreed with the international experts that what Ms. Basati tried to do was compare different types of block printing and cursive writing that cannot be compared. They called this trying to compare incomparables. For a number of reasons, her report and conclusions are wholly unreliable, even according to France. So after 3.5 years of further investigation, with Dr. Diab languishing in a French maximum security prison, and it's worth noting that our Court of Appeal opined in Canada here that it was clear to them that Dr. Diab would not simply languish in a French prison, but would proceed promptly to trial. Nothing of the sort happened. Exactly as we argued, he languished for 3.5 years in a French prison, while investigators, both of them investigative judges, concluded their investigation. They concluded there was no reliable evidence of guilt and substantial evidence of innocence. French media reported the investigators, quote, clearly believed Hassan Diab was innocent. They dismissed the case. Hassan Diab was freed and in 2018 returned to Canada. Never before had this happened in a French terrorism case. French media reported that the victims were outraged. They wanted someone held responsible, and they continued to lobby for an appeal, which of course led to this appeal court and the judgment that came today. Importantly, the French investigators revealed previously hidden evidence. A, that contrary to what France had said from the outset, that there was no fingerprint left by the bomber on the hotel card, there was in fact a fingerprint. France misrepresented the truth to Canada, and that France also knew that they had compared that fingerprint with many individuals, including Dr. Diab, and he was conclusively excluded. That is not opinion evidence, that is scientific evidence. So even before France had come to ask Canada to extradite him at the request of France, they knew, the French, that there was fingerprint evidence that excluded Dr. Diab as the bomber. In addition, The French investigative judges revealed in their report dismissing the case against Dr. Diab that multiple fingerprints were left on the bomber's police statement when he was briefly in police custody in Paris. Canada, during the course of the extradition proceedings here, had France send the bomber's police statement to the RCMP for fingerprint analysis. All of the fingerprints on the bomber's police statement excluded Dr. Diab. Privately, Department of Justice lawyers told the French in correspondence that this was powerful, if not conclusive, evidence. The Canadian judge, however, was not told this during the extradition hearing. And Dr. Diab was extradited to France with Department of Justice lawyers in Canada urging that the case was reliable enough to go to France. The French repeated the fingerprint examinations on Dr. Diab's arrival in France with the same conclusion. Dr. Diab was conclusively excluded. He was not the person who left the fingerprints on the bomber's statement. And thirdly, the French investigative judges produced independent evidence from the University of Beirut, both in the form of witnesses and documents, proving that, in fact, Dr. Diab was, as he had always said from the outset, at the University of Beirut writing his exams when the real bomber was in France in late September or early October of 1980. The French appeal court has had this case on appeal for over 3 years. Even the appeal court tried to shore up the handwriting opinion, asking for these fourth and fifth handwriting experts to opine. Must understand there are only 3 new things in evidence from the point in time at which the French investigative judges dismissed this case, calling Hassan Diab clearly an innocent man. First, that Hassan Diab in the latest handwriting report has been excluded as the writer of the only cursive writing part of the hotel card, the date. And the French case proves that the bomber himself wrote the date on his registration card. Hassan Diab did not write that date. Second, as to the block printing on the report, where all the previous French reports preposterously claimed that Hassan Diab was the author and identified as the author, this report says no conclusion can be reached. He can't be excluded. He can't be included. It's an inconclusive report because this is block printing. Millions of people in the world could not be included or excluded. It is not cursive writing. There is therefore no longer a French claim of a positive identification by handwriting opinion. That has disappeared. The entire basis for the Canadian extradition has evaporated. And third, what the Department of Justice lawyers called the smoking gun that justified a Canadian judge to extradite Dr. Diab has been ruled methodologically unreliable for use by France. So where are we today and why is this such a travesty of justice? The French appeal court suggested that Hassan Diab be put on trial in France anyway, so that the victims could have a trial. It's worth noting, media have reported at the hearing recently of this appeal, the General Prosecutor's Office maintained its requests for reversal of the dismissal while admitting doubts about the presence of Mr. Diab in Paris on the day of the attack. They admit that they doubt he was even there, yet they say that the body of evidence, such as it is, deserves to be debated in a trial court. I respectfully submit that no justice system worthy of its name offers an innocent scapegoat to satisfy a demanding lobby. The prosecution of a demonstrably innocent man damages the credibility of France's justice system. This is a case like the infamous Dreyfus case, where France is not distinguishing itself. The prosecution of a demonstrably innocent man greatly benefits the real perpetrator or perpetrators of this heinous crime. Now they can relax that someone has been fingered. And the prosecution of a demonstrably innocent man is no service to either the victims or to the French public. Since the Canadian Prime Minister in 2018 on Hassan Diab's return to Canada told the Canadian public that what happened to Dr. Diab never should have happened and should never be repeated, not only is there no new evidence of guilt, there is additional overwhelming evidence of innocence. The only new evidence in this case points out even more strongly the innocence of this man. One, the fingerprint on the hotel bomber's card is not Hassan Diab. Two, the fingerprints on the bomber's police statement are not Hassan Diab. Three, the third French handwriting report, the Bassati report that justified, according to a Canadian judge, the extradition, has been identified by France itself as completely unreliable by being methodologically unsound. Four, there is independent evidence from the University of Beirut in the form of witnesses and documents showing that Hassan Diab was in Beirut at the university writing exams while the bomber was in Paris carrying out the crime. Five, the latest handwriting report excludes Hassan Diab as the writer of the date on the hotel card. It is not Hassan Diab. And six, the newest French attempt at a handwriting opinion destroys the sole basis on which Canada extradited Hassan Diab in the first place. At the most, it can be said it's inconclusive, but the methodology used by the prior handwriting expert was totally methodologically unsound. So we are at a terrible state now where a man, an innocent man, a demonstrably innocent man, and his family, who have been enduring this nightmare for 10 years now, is going to be dragged through a future of uncertainty, while for political reasons, this case marches on in France. Thank you.
Thanks, Don. So, Alex Neve.
Thank you very much, Roger, and good morning, everyone. The list of adjectives that describe what these past 12 years have entailed for Hassan Diab and his family grows ever longer, and none of them truly capture the toll it has taken. Interminable, farcical, politicized, labyrinth, injustice, Kafkaesque, all of that and certainly much more. And this unbelievable news from Paris this morning that still, after the many deep failures of justice in this case have been exposed, still this goes on, is beyond disappointing. It is in fact devastating to learn that rather than ending injustice, the French appeal court has opted to extend injustice. From the moment that extradition proceedings were launched in 2008 to this appeal court ruling today that he should indeed face a trial, the insistence by French authorities on pursuing Hassan Diab has been cruel and baffling. No matter how much evidence has come to light, well summarized by Don, making it clear that the central evidence being used against Hassan, handwriting analysis, is entirely unreliable, that fingerprint evidence is exculpatory, or that evidence actually points to Hassan being far from Paris sitting exams in Lebanon at the time of this tragic bombing. No matter all of that, French authorities have not relented. And the human rights impact on Hassan and his family has been grave and extreme. Most notably, Hassan Diab endured more than 3 years of being imprisoned in Paris in a maximum security facility without being formally charged, without being brought to trial, and the unbearable suffering and cruelty of being held in solitary confinement for almost that entire time. That contravenes so many fundamental international human rights obligations binding on both France and Canada, be it with respect to arbitrary detention, fair trials, and even torture and ill treatment. And what further human rights concerns does today's ruling now point to? Is there even the stunning possibility that we could be looking at a possibility of a trial being held against Hassan Diab in absentia, in his absence? There must, of course, be justice for the terrible 1980 synagogue bombing. But there is every reason to believe that the way this case has progressed is much more about politics than it is about law and justice. And as a result, Hassan Diab's human rights have been subverted, sold short, and violated at every turn. There may be hesitation on the part of Canadian officials to intervene at this stage. No doubt the view may be that the French justice system should still be allowed to run its course, and Canada should not interfere in that. But when it has been so abundantly clear for so many years now that the prospect of justice in France has long ago evaporated, that view can no longer prevail. And given that the decision of the Canadian government to extradite Hassan Diab to France over 6 years ago played such a pivotal role in enabling all of this injustice, there is a particular expectation and responsibility that Canada step up now. Canada is not just an interested bystander, but is directly implicated and must seek to defend Hassan's rights. As such, we all look to Prime Minister Trudeau, Foreign Affairs Minister Garneau, Justice Minister Lametti to make it clear to their French counterparts that Canada is of the view that the proper course of action at this stage is for French authorities to drop these unfounded charges against Hassan Diab and not continue with this prosecution. Human rights demands nothing less. Thank you.
Thank you, Alex. So now Rob Currie.
Thank you, Roger. I only have a couple of brief points to add that may be hopeful or helpful from a process point of view. The French Court of Appeal having issued its decision today, that decision may be appealed by Dr. Diab's lawyers in France, and my understanding is that that will go forward. That would be an appeal to the highest court in France. Now, if that appeal is unsuccessful, then there are a couple of options on the table. The government of France may, under the Canada-France extradition treaty, request Dr. Diab's extradition again, amazingly, to face a new trial or a new proceeding. Alternatively, French criminal law allows for there to be a trial in absentia, as Alex Neve mentioned a moment ago. That's an option that the French government may choose to avail itself of. So that's the situation that we're faced with. That, again, incredibly in this case, there could be a renewed French extradition request for Dr. Diab, even on the basis of all the foregoing history. Now, I want to echo something that Mr. Neve said a moment ago. As a matter of international law and diplomatic practice, it is entirely within Canada's remit to make diplomatic representations to France asking that this prosecution be dropped. That would normally be an unusual kind of request for one country's government to make to another, because typically any government does not want to be seen to be interfering in the criminal justice process of a foreign state. But this is an unusual case. France is an extradition treaty partner with Canada, and there's absolutely nothing preventing the Canadian government from making such representations. The question, as Alex said, is one of political will. That said, if there is a new extradition request from France, then the Canadian extradition process would run as it normally does. But that request would have to be assessed against the backdrop of this case, which Donald Bayne has so laid out in such a detailed manner. And there are obviously a number of concerns about a potential re-extradition in a case where the individual was released for lack of evidence, but is now sought for a trial on the basis of less evidence than there was before, less evidence against him, and more evidence pointing away from his guilt. And that is something that both phases of the Canadian extradition process would look at, both the judicial phase and ultimately the Minister of Justice in deciding whether extradition would be granted. That's all I have. Thank you.
Thank you, Rob. So we'll move to the question and answer period. I think it's already been indicated to you journalists that you have to indicate your wish to ask a question through the chat function, and you will be called on in the order that they are received. You will need, of course, to unmute yourself when you ask the question, and you may wish to indicate who you're directing the question to, or whether you're asking all three of our speakers. So please, when you do ask the question, identify yourself again and give your media affiliation. That would be helpful to everyone. And of course, we will entertain follow-up questions if appropriate. Les questions en français seront également acceptées. And just like to thank Tim Sawley and Anne Dagenet-Gertin of the International Civil Liberties Monitoring Group for their technical help and support. I wanted to say that right now. So without further ado, let's move to the questions.
Great. The first question is from Lina Dib. La première question est de Lina Dib de la Presse canadienne. Please go ahead.
Oui, bonjour. I think I'm going to try it in English for Mr. Bayne. I was wondering how much of a chance there is for an in absentia trial for Mr. Diab. And my other question to you is, you said that the justice system is offering an innocent scapegoat to satisfy demands of a lobby. What lobby are you talking about?
The lobby I'm referring to is the victim lobby. In France, victims can have lawyers represented throughout the criminal process, representing them. And in this case, there is a very powerful lobby that has been very vocal from the outset. They were outraged when Dr. Diab was released and sent back to Canada, and seem more interested on having someone to blame than the state of the evidence. In terms of the likelihood of a trial in absentia, I really think you would have to talk to William Bourdon, Amélie Lefebvre, or Apolline Cagnat, who are the three French lawyers who've been representing Dr. Diab in Paris, who better understand the French system. I would be conjecturing. I simply don't know what France will do next, because so much of this case has been unprecedented. And there seem to be unusual factors motivating the case rather than the state of the evidence. I hope that answers your question.
Any follow-up?
Yes, thank you.
Okay, we'll move to the next question from David Cochrane at CBC.
Hello there, gentlemen. I've just spoken with Amélie and Apolline in Paris about this, and their sense is that this decision, they've described it as a politically correct decision, in that it is practically impossible for the legal system in France to allow the sole suspect of the Rue Copernic attack to go without it going to trial, regardless of what has happened with the evidence, which is, based on these latest revelations, seems even weaker than it was when Judge Moranger ordered the extradition. So I wonder if you share that interpretation that no evidence of any kind will convince them to drop this case. And if that's the reality, what would you like to see Prime Minister Trudeau and the federal government do here?
Well, I could go first. I'm sure others will want to add to this as well. I think that is very much the reading that all of us have as to the wider context of. Because I think everyone hungers for an answer to the question, why? How can it be that in the face of such overwhelming evidence of Hassan Diab's innocence here, which as Don has powerfully sketched out for us, only continues to grow, that justice does not prevail here. And I think it absolutely does point to that wider political context. And I think we've all been aware that that is a considerable force marshaled against Hassan throughout this entire process. That doesn't make it right, obviously, far from it. But I think we all understand that to be the reality here. Therefore, that in many respects points to why it's even more important that the Canadian government become involved, because the usual arguments that justice is a neutral and impartial process, and that in a country such as France, a close ally, a well-developed justice system, other governments should respect that, must carry the day. But this case is an exceptional case. Not to suggest that there couldn't be other cases like this arise in France, sadly, but we're faced with this one very exceptional case, which points to a much wider political dimension as to what's playing out here. And therefore, there is a very serious responsibility incumbent upon the Canadian government to become involved, not just to stand by with those usual lines of justice is running its course, and that's going to have to be including at the very highest levels of exchange between the two governments, given that the political considerations that need to be dislodged here on the French side are considerable. So that's why we're looking to Canada to make that intervention and to do it at several levels of exchange between a variety of senior government, the Prime Minister and ministers.
I might add too that it's in terms of what what one might want the government of Canada to do at this point. Again, it should be recalled that Prime Minister Trudeau said that what happened to Dr. Diab should not have happened, and that something needed to be done to ensure that it didn't happen again. And I think it involves the kinds of representations that Alex just referred to. I also think it's incumbent on the government to examine our extradition laws, the time for reform of which is certainly here and has been here for a while. And it's really long past time that the government looked at reforming our extradition process, which saw the extradition of Dr. Diab to France in this very questionable case to begin with. There have been numerous calls for extradition law reform, so far fallen on deaf ears, and just wondering if that must be part of any serious response to this case.
Any follow-up question?
Yeah, just one quick follow-up. I know we're a long ways away from this because Mr. Diab's lawyers in Paris have told me they have appealed. So that's a process. That's a year to 18 months, most likely. And then no request for extradition could follow until the Supreme Court there conclusively determines whether or not a trial will happen. But I wonder, and Mr. Bayne, maybe you can speak to this. If he is tried, and I know we're jumping down the process here, if he is tried in absentia and he is convicted, even though the evidence, as you spelled out, suggests a weak case, would he not, Dr. Diab, not then be at risk of facing an extradition request, not to stand trial, but to serve sentence? And that puts him at an acuter risk than he was even 12, 13 years ago when this whole thing started.
Yes.
Okay, thank you.
Thanks. Next, we'll go to Jim Bronskill from the Canadian Press.
Hello, good morning. I I'm just wondering if there has been any conversation between Mr. Bayne and Mr. Diab about the decision today. If you could tell us something about his reaction and how he's taking this.
Mr. Bronskill, this is devastating. This has hung over a family's head. There's a husband, a wife, 2 little children. These are people trying to carry on a life here in Canada. It's absolutely devastating. They live every day on a tenuous life. And they thought that there was some light at the end of the tunnel when they came home, when Dr. Diab came home in January of 2018, and particularly after Prime Minister Trudeau made plain that this never should have happened. This was a wrongful extradition that never should have happened and should never be allowed again. And yet, the process of injustice has ground on in France, owing to the powerful lobbies that are pushing this case, despite the evidence. As I said at the outset of my remarks, it's really in the face of the evidence that this decision comes out. This isn't a decision supported by the evidence. The evidence is weaker now than when the French investigative judges carefully looked at the case for 3.5 years, concluded the man is innocent. The evidence of innocence is overwhelming, and there are too few tenuous, unreliable strands of inculpatory evidence even to justify a trial. The evidence has grown weaker since then because the sole thread of this Vissotti report has been unraveled. It's unreliable, even the French say. So now they don't even have handwriting. And yet they've ordered a man to stand trial. I think Alex and Rob said it well about the political realities of this case. And I know from my conversations with the French lawyers that that is very much their view of what is going on.
As Professor Currie suggested, diplomatic representations could be made to federal authorities to make diplomatic representations to France and say, look, lay out what you've said today, that this case is a travesty. There's no basis for proceeding in France. Will you write any such letter to the Prime Minister or to the Justice Minister to that effect?
I'm going to consider all legitimate avenues in protecting my client. Yes, I will. And I may say, Mr. Bronskill, it's encouraging to have the other members of this press conference and the groups that are internationally recognized as defenders of human rights also identifying this as a miscarriage of justice.
Thank you. Next, we'll go to Kevin Gallagher at CTV National News.
Hi. You've talked a lot about reforming the extradition process and that there's a lot of political factors interfering with this. I know that the case is unrelated to Mr. Diab's, but there certainly is a high-profile extradition case that is politically sensitive for the government now in terms of the case of Meng Wanzhou. Do you anticipate, or are you concerned that the reforms you seek you may fall on the government being less willing to tackle those, given the political delicacy of the Meng Wanzhou extradition ongoing right now?
Who is being asked that?
I could start. We may all have views on this. I think the easy answer to that, Kevin, is yes. Clearly, the very sensitive context around Meng Wanzhou's case means that there will be considerable reluctance and caution on the government's part in even indirectly signaling that they agree that there's a need to revisit or reform the Extradition Act. That doesn't mean that those of us who are concerned about the many ways in which over many years there have been cases of concern, Dr. Diab's being such an extreme instance, which make it clear that the Act does need to be reformed in order to much better protect human rights. That we need to start that conversation. We need to be starting to press and make the case for reform, because that's not going to happen tomorrow. Even if the case begins to build and there is growing recognition on the part of government officials that they should pursue this someday, we've got to get that conversation happening now. So I think that's why you're hearing, as Professor Currie has signaled in his comments, that we need to have the conversation about reform, even if it's not going to start tomorrow.
Can I just add to that as well, Kevin, that even if the Act were to be reformed down the road, the normal expectation would be that it wouldn't affect the Meng Wanzhou case, in that a new Canadian federal statute is not applied retroactively. So if there were changes to the Act, that would be a new Act that would handle cases that came in after that date. But on the other point of the political considerations, I think the one that this case highlights is the need to examine our extradition relationship with France. And I think Canadians who make themselves familiar with this case might have some questions about that. In a Canadian criminal case where the prosecutors acknowledged that there were doubts about the guilt of the victim, my inclination would be to say they have just admitted there's a reasonable doubt in the case and there's no prospect of it going forward successfully. And are we really going to continue extradition relations with a country where this kind of stuff goes on without looking at that, without the serious conversations between high-level officials, and without considering what the parameters of our extradition relationship with France are? Because both Human Rights Watch and Amnesty International have raised concerns over the years about the French criminal justice system. It's high time, I think, that particular relationship be examined.
Any follow-up?
Yes, a follow-up, please. Thank you. Since the reform seems to be a longer-term request, what request is there in the short term from, let's say, Mr. Bayne towards the government to ensure, what you're talking about with your client, that his rights aren't violated in this sense? Is there a short-term request of blocking extradition of France? Maybe just sort of highlight what it is you want to see in terms of action from the government right now.
I don't think there's any quick fix. I think government officials would agree that reform has to be carefully considered and not a knee-jerk. There's a history of problems with our extradition system. Let me give you an example, among many, by the way. The fact that there's no sworn evidence required to extradite a Canadian, the fact that all it takes is a signed document by some foreign official who can't be cross-examined or challenged. No right to challenge the allegation. There's no disclosure of the exculpatory evidence. For example, in this case, the Department of Justice lawyers have said when they got the powerful, if not conclusive, evidence of innocence of the RCMP fingerprint test of the bomber's fingerprints on his own police statement, and it wasn't Hassan Diab, they chose not to disclose that to the judge, even though it was during the course of the proceedings when we were appearing before that judge, because the law doesn't require them to. Now, whether professional obligations or others, that's a different issue. But the key is the test for reliable evidence to deprive a Canadian of liberty is so tragically weak that this case, where the world's leading handwriting people said this Bassotti opinion is completely, not partly, completely unreliable because the woman didn't even use accepted methodology, didn't seem to understand how to do a handwriting comparison examination. She tried to compare incomparables. That was held to be, okay, there's problems, but it's reliable enough for Canadian extradition law to deprive a Canadian of liberty. That reliability test has to be examined, and the courts can do that too. This is jurisprudence that has developed that part of it. There's both a second look that has to be taken seriously by the courts and a hard look by the government. In terms of quick action, I'm going to sit down with the clients and talk to them about their life, their instructions, and what course we should now follow. But I don't think I'm going to be suggesting any unreasonable or knee-jerk responses by the government. A careful, humane look at this circumstance, the way Alex and Rob have described it.
Thank you. There's no other questions right now.
Okay, thank you, Tim, and thank you, Don and Alex and Rob.
Oh. Roger, I think we may have lost your audio.
We've lost you, Roger.
He's not muted. Let's send him a message.
Legal processes and so on were at play, and that Hassan was in fact a victim of that miscarriage. We're also very aware that the strong lobby in France that has been referred to is still and will be very active. It's noteworthy that in the last couple of days, I saw only 2 significant comments in the French media. One of them was published by I-24, which is an Israeli-based news site with ties to Netanyahu. The other comments were by Jean Chichizola, who is an assistant editor with the Paris newspaper Figaro. And Chichizola wrote a book many years ago about this case, and he has a vested interest. All of this to say that our hearts are with Hassan and Rania and the family, that our determination to keep going is strong, and that we will not allow this injustice to be further perpetrated. So thank you all for taking part today. Thank you for your questions. I hope that we get a chance to talk with you again in happier circumstances, but in the meantime, the fight goes on. So thank you and goodbye.